Speaking of Florida, we're going to go there for a different reason. A lawsuit by Hulk Hogan against tabloid website Gawker that some say will forever change the way websites handle celebrity news and beyond. The case centers around Gawker's posting a 2-minute explicit video of Hulk Hogan having sex with the former wife of his best friend. Gawker says their action is protected by free speech under the First Amendment. But Hogan's lawyer argues it violated his right to privacy, and they're demanding Gawker pay up to the tune of $100 million in damages. Today, the Hulk is taking the stand again after testifying yesterday about who recorded the tape, allegedly his once best friend.
My question was, he lied to you, right?
Yes, sir.
Okay. And you asked him man to man whether he filmed you, and he lied to you, right?
Yes, sir, he did.
All right. And you looked him right in the eye, and he lied to you, right?
Yes, sir.
Okay. So you said to him, as my best friend, I need you to tell me the truth. And despite that, he lied right to your face, didn't he?
Yes, sir, he did.
Okay. At that time, you believed Bubba completely, didn't you?
At that time, I did believe him completely. There was no reason not to.
These Wheels of Fox News legal analyst. Bob Bianchi is a criminal defense attorney, former head county prosecutor and trial attorney. It's great to have you both. You know, when you hear sex tape celebrity case with the tabloid website, it's easy to sort of shrug your shoulders and be like, oh, great, here's another one. But this is something very differently. And some are saying that this case will define what is actually newsworthy and what's actually private from now on. Why is this case so significant?
Well, because the issue here is exactly that. Because he says, Hulk Hogan says, look, I didn't know I was being taped. I didn't mean to have this out there. My best friend did it, unbeknownst to me, that it was leaked to Gawker. So Gawker got it. He's suing Gawker, right? Gawker got this. Then Gawker got the tape and then put it out there and have this commentary running along with it. Gawker is not in trouble for doing that. It's not illegal for a journalist to put out something that they got, even if they obtained it illegally. That's important. Even if they obtained it illegally, it's not illegal for them to put it out there. Then it becomes the question, though, okay, even if you obtained it illegal and but you're putting it out there is legal, is it then newsworthy? If it is newsworthy for the public, then it is something that is protected under the First Amendment. If it is not newsworthy, if it's just purient interest and invades the privacy of an individual, then you have a problem. It's the privacy then clashing with the First Amendment. That's why this is so important.
And that's what's so interesting about this, Bob, because that's the argument here by Gawker, is that this is newsworthy because the man on the stand is not a man with the name Terry. He's Hulk Hogan, and he's talked about his life, his private life before. Therefore, his private life is actually public, and we're going to be able to post anything about him. What about that argument?
I think this argument is not a good argument. I think legally this is a test case that is going to have the two constitutional principles of an individual's right to privacy and the media's First Amendment. The law has not caught up on the internet and how fast these things move. And of course, we have more news agencies putting out there salacious materials. Nothing is more protected in the Constitution than a house and your bedroom. And what they did in this particular case was they pushed the line. Since 1995, the Supreme Court and federal courts have been saying there is a line by which the media can breach. And I believe that this is going to be the case where these jurors, who are not going to be very sympathetic to their anybody's bedroom being violated, may very well say the media has gone too far, and we will now see the Constitution start to now emphasize privacy rights over the media's First Amendment right to write anything that it wants. We've gone too far journalistically with this. It has no inherent value to the community. It is not protecting democracy, which is the reason the First Amendment would do these things. This is an outrage, and I think that this case is going to be a test case. It's going to say to the media, you've gone too far, and now you can no longer do these things. This is an outrageous, in my opinion,
We're going to talk more about the outrageousness of this whole case. But as you point out, Bob, the media rarely loses in these cases. So I have to take a quick commercial break. So hold that thought, Lisa. I'm going to come to you quickly after the commercial break, and we're going to talk more about this case.